Good afternoon, ladies and gentlemen, and welcome to Field Fisher's webinar on the ICO's Age-Appropriate Design Code. My name is Leonie Power. I'm a partner in Field Fisher's Privacy, Security and Information Law team, and I'm here today with Lorna Cropper, a director in that team, and Camille Ebden, an associate of that team, and together we will take you through the ICO's Age-Appropriate Design Code, or Children's Code as it's also known. Next slide, please, Lorna. Before we launch into the agenda and what we're going to take you through, I thought it would be a good opportunity to debunk some myths. So myth number one, the code covers everything to do with children online, so content, available technology, etc. This is indeed a myth because in fact the code only covers data protection. It is, however, just one piece of a very large picture, and some of you may be aware of draft and proposed online harms legislation that looks at protecting children online to beyond data protection. Another myth, children's personal data is just dealt with in Article 8 of the GDPR, and some of you may be familiar with Article 8, which talks about the provision of information society services to children. And in that context, if there is reliance on consent as the legal basis for the relevant data processing, then Article 8 talks about the need to get verifiable parental or guardian consent. However, this is just one specific aspect of the GDPR that deals with children, but the broader GDPR principles apply as much to children as they do to other individuals. And in fact, the GDPR talks about children's personal data meriting specific protection. Another myth, I can't carry out any form of marketing involving children. That is indeed a myth. Again, as I've just said, the GDPR does state that children's personal data merits specific protection. However, that doesn't mean that you can't carry out any marketing in relation to children. You just have to make sure that you are compliant with the GDPR to the extent that you do so. So processing must be fair. You mustn't exploit any lack of understanding or vulnerability on the part of children, and you will need to carry out a data protection impact assessment. You'll also need to exercise care to the extent that there are rules around automated processing activities having a legal or similarly significant effect. And in some cases, depending on the nature of targeted advertising, such advertising could be deemed to have such a significant effect if you take into consideration the vulnerability of children. Another myth, well, we don't aim our services at children, so we don't need to worry about the age-appropriate design code. Again, the criteria here is that the code applies to information society services that are likely to be accessed by children in the UK. So this is potentially an extremely broad scope, and we'll consider that in a little bit more detail later. And finally, another myth is something along the lines of my service is used by over 13s only, so I don't need to worry about data protection of children. Again, the age 13 is a specific age that comes up in the context of Article 8 of the GDPR. So the GDPR talks generally about, in Article 8, about the provision of information society services to a child, and where reliance is on consent in that context as the legal basis for data processing, we've said that Article 8 talks about the need to obtain verifiable parental or guardian consent. Now, child for the purposes of Article 8 is defined as anyone under the age of 16. However, this is one of the places within the GDPR that envisages local law clarification or exception. So it's open to member states to reduce that age from 16 to a lower age down to the age of potentially 13, which actually is the case in the UK. But that's only in the context of Article 8. In relation to the application of the GDPR more broadly, child is broader than an individual under the age of 16 or under the age of 13, as the case may be. And we need to look at the definition of child that is contained in the United Nations Convention on the Rights of the Child, which is basically a person under the age of 18. So when considering the broader aspects of the GDPR, you need to bear that in mind, and certainly you need to bear it in mind in the context of the application of the age-appropriate design code. Okay, so now that we've debunked some myths, let me just quickly run through what we're going to cover today. Well, first of all, we just want to provide it a little bit of context to set the scene and look a little bit at the international picture in relation to protecting children's personal data. Then we'll give some background and introduction to the Children's Code. We'll move on to talk specifically about the 15 standards that are outlined in the code. And we'll then do a deeper dive in relation to profiling, data protection impact assessments, and the use of nudge techniques. And finally, we'll wrap up with some key practical takeaways. Next slide, please, Lorna. Okay, so the code is very much the first of its kind, but it does reflect an increasing global movement towards enhancing the protection of children's data. So if we look at California, for example, we see that businesses that are subject to the CCPA cannot sell personal information of consumers who are 16 years or younger without prior authorization. And where the consumer is younger than 13, that authorization has to be obtained from the parent or guardian. Looking at the EU then, we see that the CNIL, the French data protection regulator, this year ran a public consultation on protecting minors' data while respecting their rights. Swedish authorities have released a guide for digital service providers to support children's rights. And in addition, many member states' blacklists for data protection impact assessments require that a data protection impact assessment is carried out where processing relates to children's data. Again, you'll remember that Article 35 of the GDPR envisages that supervisory authorities can introduce lists of situations in which a DPIA must be carried out. And many of the member states have said that one of the situations in which a DPIA must be carried out is if it involves the processing of children's data. And then we've had a number of developments across the APAC region in relation to the protection of children's data. China, for instance, has introduced comprehensive measures aimed at protecting children's interests in the use of their personal information. And then there's broader data protection legislation, which also provides for children privacy rights. And that's been passed in Thailand and is expected soon in India, among other jurisdictions. So that gives you a little bit of a flavour of some of the cross-jurisdictional developments. And on that note, I will hand over to Camille, who will give you some background and introduction to the code itself.
Thank you, Leonie. Afternoon, everyone. So yes, to dive into some introduction to the code. So the Age-Appropriate Design Code is a statutory code, and it came into force on the 2nd of September this year. It's going to be applicable from the 2nd of September next year. So those in scope should be getting compliant ahead of that date. It sets standards and explains how the GDPR applies in the context of children using digital services. And it's going to apply to information society services, ISS, that are likely to be accessed by children in the UK. And as Leonie mentioned, this is potentially an extremely broad scope, and we're going to break it down a little bit further. The code comprises a set of 15 standards, and the code sets out that it aims to protect children in the digital world rather than to protect them from it. So next slide then, please, Lorna. So now to kind of look in a little bit more detail at who the code applies to. So as mentioned, it applies to providers of information society services, ISS, that process personal data and are likely to be accessed by children in the UK. So looking firstly at information society services, the definition of this essentially captures most companies that provide online products or services, including apps, programs, websites, games, and connected toys or devices, both with or without a screen. However, the code does list some services that are not covered, and these include certain services provided by public authorities, websites which just provide information about a real world business or service, scheduled TV or radio transmissions, and also preventative or counselling services. But as we've mentioned, the most difficult question for determining whether the code applies to you is when is a service likely to be accessed by children? So if we could turn to the next slide. Thank you, Lorna. Firstly, again, it's important to bear in mind that for the purposes of this code, as we've mentioned, a child is a person under 18. And it's clear that the code applies to services that are designed for and specifically aimed at under 18s, but clearly its application is broader than that. The ICO says that whether a service is likely to be accessed by children depends on the possibility of this happening being more probable than not. So the code says that there are some factors that you should weigh up when assessing whether this is the case or not. And these include the nature and content of the service and whether they have particular appeal for children, and also whether you have any measures in place that prevent children from gaining access. The code also sets out that if children form a substantive and identifiable user group of your service, then your service should be deemed likely to be accessed by children. While they don't provide further details of what counts as substantive, they do say organisations should take a common sense approach. The code also somewhat helpfully says that the ICO recognises that it will be possible to conform to this code in a risk-based and proportionate manner, given the code's breadth of application. So this seems to suggest that possibly the code could be applied to a greater or lesser extent, depending on the risks posed by a particular service or a particular area of a service. In any event, if you decide that your service is not likely to be accessed by children, and that you're therefore not going to implement the code, you must make sure that you document your decision and your reasons. The ICO suggests that such documentation could refer to market research and current evidence on user behaviour and evidence from looking at similar services. So to recap, the key factors in determining whether your service is likely to be accessed by children are: is it more probable than not in terms of the nature of your content and the accessibility of your content? Do children form a substantive and identifiable user group? And then lastly, make sure you document your decision and your reasoning. So on to the next slide. Does the code apply to services that are based outside the UK? So clearly it applies to online services that are based in the UK. It also applies to services based outside the UK, but with a branch or establishment in the UK that process personal data in the context of the activities of that establishment. And it also applies to online services that are based outside the European Economic Area, the EEA, and that are offering services to or monitoring the behaviour of UK users. However, if you don't have a UK establishment, but you do have an EEA establishment, and you offer your services to or monitor UK users, currently the code does not apply to your service, essentially because you should fall under the one-stop shop system. But the code will apply to such services in the future. It depends a little bit on Brexit when it will apply, but if the UK does not have a deal by the end of this year, then the code will apply to such services from the 1st of January 2021. If the UK does end up with a deal, the code would apply to these services from the end of the deal's implementation period. So on now to have a look at the 15 standards. So they cover quite a broad range of topics, from transparency and detrimental use of data to geolocation, parental controls, connected toys and devices. A key theme that runs through all of them is actually the first standard, the best interests of the child. So the best interests of the child should be a primary consideration when you design and develop online services likely to be accessed by a child. Now, we're going to focus today on 3 of the standards in particular. So I'll move on now first of all to profiling. So profiling is standard 12, and I'm sure many of you will be familiar with the GDPR's definition of profiling, which essentially sets out that profiling is any form of automated processing of personal data to evaluate certain aspects relating to an individual, in particular analysing or making predictions concerning aspects relating to an individual, such as their health, their personal preferences, their interests, behaviour, and location, to name a few. In practice, profiling often takes the form of using a user's browsing history to suggest or serve content to users. Now, Standard 12 of the code highlights that it's important because it's mentioned in Recital 38 of the GDPR as an area where children merit specific protection. The key message of Standard 12 is that you should switch options that use profiling off by default unless you can demonstrate a compelling reason for profiling to be on by default, taking into account the best interests of the child. So what can some of these essential reasons be? One such compelling reason detailed in the code is where the profiling is essential to the provision of the core service that the child has requested. However, they emphasize that this should be interpreted narrowly, and the profiling needs to be completely intrinsic to the service requested. Other compelling reasons that they suggest could be where the profiling is needed to make a service accessible to a child with disabilities, or where it's needed to meet legal or regulatory requirements, such as safeguarding, or in order to age assure in order to comply with this code. The code also states that it might be possible to demonstrate that profiling for the purposes of informing news content feeds should be allowed for by default. Looking at behavioral advertising, the code sets out that there should always be a privacy setting for behavioral advertising where this is not part of the core service that the child wishes to access. And the ICO expects that there will be very few cases where behavioral advertising is part of the core service, such as vouchers or money off services. If you do allow profiling, the ICO set out that you should only do so if you have appropriate measures in place to protect the child from any harmful effects, in particular being fed content that is detrimental to their health or their well-being. And then we have the topic of cookies and similar technologies. Here, the code has a reminder in Standard 12 that you need to consider the UK's privacy and electronic communications regulations regarding the setting of the cookie, as well as the GDPR and the code in terms of the underlying processing of personal data that the cookie is supporting or enabling. Under the privacy and electronic communication regulations, prior consent has to be obtained for any cookies that are not essential to the service requested by a user. A difficulty is that under Article 8 GDPR and the UK Data Protection Act, as Leonie has mentioned earlier, where consent is the legal basis relied on for an online service, parental consent should be obtained for any individuals under the age of 13 in the UK. So the code deals with this issue a little in Annex C, which references the fact that Article 8 GDPR also sets out that controllers only need to make reasonable efforts to obtain and verify parental consent for children under 13. Annex C states that available technology, resources, and the level of risk are factors that controllers might be able to take into account when deciding what is reasonable for the purposes of complying with Article 8 and getting parental consent. So, to recap on this slide, the code's key messages on profiling are to switch off profiling by default, unless there's a compelling reason for the profiling, to have appropriate measures in place to protect children from harmful effects if profiling can be switched on. And when it comes to cookies, you have to consider PECA, the GDPR, and this code. So I'm now going to hand over to Lorna.
Thank you, Camille, for that. And just waiting for my own slide to come up, slight time delay there. So as we've already heard, within the blacklists that many data protection authorities have produced in accordance with Article 35(4) of the GDPR, many are requiring that a DPIA is done for children. So, for example, in its own blacklist, the ICO at number 9 says targeting of children or other vulnerable individuals. And where that is the case, a DPIA needs to be done. So therefore, it comes as no surprise that there is a DPIA requirement in the code. And I'm sure for those who are already carrying out data protection impact assessments, you will probably have a procedure in place and perhaps already doing them where your data processing involves children. There is at Annex D DPIA template provided by the ICO, because what's also required here, which we'll come on to explore in a little more detail in a moment, is the additional considerations that you have to take into account under the code and meeting your compliance standards with the code. And as you'll appreciate, DPIA, it's about identifying and minimizing risks, and then identifying and fixing any problems at an early stage. As we know today, data protection is interwoven from the start to the end of a project cycle. It's not a bolt-on. So similarly, when you're creating new data processing with regards to children's data, you need to be thinking about it from the start. So what do these additional considerations under the code look like? Well, the code actually breaks down children into different age categories. And within those age categories, for example, 0 to 5, 6 to 9, 10 to 12, 13 to 15, 16 to 17. So those are the different ages of children that have been broken down. And you may, for example, have to create different systems which are appropriate to those ages, and you have to look at development needs. Now, you can appreciate the development need of a 16-year-old, 17-year-old, very much a young adult, is very different to a 10-year-old, yet both could be looking at similar services that you provide. And what is potentially quite a big ask is that you have to look at each standard, so all those 15 standards of the code within your DPIA as well. I mean, it may be that some of those are quite easily dealt with, but nonetheless, it's a matter of recording and documenting your decision-making process. And we've already referenced this a few times throughout this webinar already. And what is also that follows on from the 15 standards within the code is accountability. So it's making sure that you are accountable for everything that you do within the code, and to demonstrate that you can and are complying with it. And within your DPIA, there's an expectation that if you're a large organisation, you will have some consultation with children and parents. And then this is underlying what Leonie said at the outset, that the code is part of a broader picture. And because not only do you need to look at the compliance, and whilst it is focused, the code, purely on data protection, you do need to consider the influences and the rights of and freedoms of children that could arise from your processing, which includes the potential for any significant material, physical, psychological, or social harms. And there is much in the media about, online activity and children, whether it's gaming, social media, just communicating online, how much time they're spending online. But there's many different things to what you do need to be taking consideration from. And also the guidance within the code discusses a variety of different steps you can take. So, obviously doing it at the outset, and then also looking at the nature, the scope, the context, and the purposes of your processing. So similarly there, what is happening with development needs and any relevant guidance or research. So not just what's happening in legislation. And similarly about well-being. So again, how much time that children spend online, and also again just considering those different needs of the age group of children that are your services are targeted at. Equally, ensuring that the data that you are collecting and processing about the necessity, the proportionality, and the compliance of that. And it's not only, looking at the lawful basis, and if you're doing AI, the different AI considerations of bias and how you explain the use of AI and security measures, but again, each explaining where what steps you've taken to mitigate the varying standards that are within the code. And within the code, for those who haven't had a chance to look at all 100+ pages yet, there are examples underneath each standard of how you can comply with the code. And the GDPR is risk-based, so there will be some risk-based decisions that companies need to make. And similarly, when identifying any risks, how do you mitigate those risks? And that's what also needs to be considered as part of the DPIA. And then ultimately, you need to record those decisions and those decisions that you have made and be able to support them, as it does say at some point in the code. You need to be able to justify those to the regulator if if they do come and want to know why you have developed a particular design. So now just looking at standard 13, and which is nudge techniques. And so a nudge technique it's used by a designer that encourages everybody, whether you're a child or not. It will nudge the way you look at a particular website, whether it's or an app, or how you engage with the screen. And what the code is saying is not to use nudge techniques to lead or encourage children to provide unnecessary data or turn off privacy protections. So for example, here in the example 1, which is taken directly from the code, shows the yes in quite a large green background color with the white yes on top, and then a small no thanks. And what should not be done is there should be no differentiation that nudges a user in one direction or the other. So for example, it may be there has to be a neutral. There's no necessarily prescriptive way to do it. There is just, and there's no prohibition of using nudge techniques, but what is made clear is how they shouldn't be used to collect unnecessary data. And similarly with example 2, it's about the use of the language. So is it more inviting to say, switch this on if you want to see videos that will really interest you, or leave this off if you want to see random videos that you probably won't like? So encouraging the child's behavior is what is, and particularly encouraging them to do something that's not pro-privacy, is very much not in compliance with the code. By contrast, you can use pro-privacy nudge techniques where appropriate towards high privacy options or well-being enhancing options. So for example, you could have a big pop-up that says take a break, because that within society is what is being encouraged, especially of children's use of IT. And equally with, you know, what's being recommended in the age appropriate design codes is when it was first came out in draft, there was a lot of headlines about how would the like button, you know, be used on this within nudge techniques. Would that be banned, or would companies still be able to use it? So I've gone for quite an innocuous example here. I've gone for a tweet from the ICO, and Twitter isn't necessarily provided to the 18 and under, or the under 18s, but what is interesting is how all the, like the home, the search, the notification of likes or messages, all very similar sizes, all very neutral. However, could it be said where if you do have the like button, you're potentially encouraging children to stay online for longer? So there is some debate that's still, or interpretation that's still available to be had within the code itself. Although, as we'll see further into the slide deck, how there are a lot of ongoing consultations about the implementation that is still going on within the ICO and beyond, about the code and other things that are happening in the children's space. So it is a matter of complying as well with the wider aspects of the GDPR. So, for example, minimizing your data collection, and then also adopting the different principles as well, and seeing how they fit within your operations as you go through your DPIA, but then look at the different other standards and how that's impacting on what you want to be doing with that children's data. So what you can't do, and this by no means is all the standards that are applicable to nudge techniques, but it just shows by way of illustration how there are a number of techniques that they do complement each other. They're independent in their own right, but then they are accumulative too. So one cannot be taken in isolation, do need to be read against the others, and some will clearly be more relevant to your particular design or service, but you do still need to be considering the other aspects of the code. And that is not just it, though, because as we've been hearing, you will also have those external factors to consider about the current issues and what broader risks you might get from that particular processing. And equally, there is an element within the code as well, which not only does it suggest about for large organizations to be consulting with children and parents, but it also suggests that you look at what experts are saying on particular aspects of children's behavior online. So just looking at what could be the key takeaways for you today, particularly as we consider how this code fits within the GDPR and also what you now need to do on top of your GDPR provisions. So does the code apply to you? I think this is very much the first question you need to be asking yourselves. And, you know, there's very much a broad interpretation of what is an information society service, which is clearly itemized within the code itself. And then, you know, just considering, are your services likely to be accessed and used by children? Document if you don't think it applies to you and why it doesn't apply to you. And it could be that, you know, if it doesn't apply to you today, in 6, 12, 18 months, your services change and then it may apply. And it's good then to have that, you know, determination originally and then moving forward as well. And then if it does apply, well, there are a number of things you can be doing. So where within those age categories are your users? And if you cut across all those users, or maybe your services are just 13 plus, you know, there are different aspects that you do need to consider per age group. So for example, transparency or parental controls. Equally, how do you ensure the age appropriate user base that you have got as well? And always, I suppose, when we're talking about data protection, how much personal data do you actually need to take from the young people? Or do you actually need to be collecting all that you are doing? And is it fair to be using children's data as you foresee that you may do, or how you are going to use it? Equally, high privacy settings by default, how are the default settings within that? And again, for example, your privacy notice, if your services are for children aged 9 plus, does your privacy notice read as well to a 9-year-old as it would to a 15-year-old? And that's just another practical consideration to be thinking about. And certainly just very much so to look at the Annex D and the DPIA and seeing how you can interweave all these different standards into one of your products. And maybe if when the GDPR became applicable, having a look at, you know, what DPIA or DPIAs you did then and any relevant ones, and then mapping it onto what style DPA you would now need to do under the code, and seeing any gaps that you have or any further analysis. And of course, one should be reviewing DPIAs in any event. And also there is, as we've already mentioned, a much engagement and further resources that are available, not just from the ICO either. So the ICO itself has, which just shows the actual importance of this code, and it is a statutory code, which means that it had to be drafted. It's not just guidance, and it will be taken into consideration if, you know, there are any breach obligations that you commit. So there's a dedicated children's hub with all the information that the ICO has put together on this to date. On Thursday of this week, there's a workshop that the ICO is hosting, which is by invitation only, and as in you had to apply to attend. So the date and deadline or the deadline has passed for that. So if you have applied, you'll know whether you've been accepted. But they all have workshops. They have an overall view, and then they'll have workshops. And what is expected, though, from those workshops, that there will be some further information released, because they are talking about the risk based of 4 of these different standards and how you would meet those. And equally, they are open for consultation about different aspects. So also what's very interesting is the content that was in the consultations pre-code, and then what came out in its draft and what responses were made. So as I was saying, in respect of the nudge techniques and the like button, well, they haven't been expressly prohibited. It's just a way that you need to design them. And also, again, showing the priority of children's data within the ICO at this moment in time, they are have also encouraged sandbox applications to work that are specifically focused on children. So the sandbox is where companies get to try new techniques and consider how they're collecting and processing data, and the ICO feeds back on that. And in addition to parallel work streams, are something that's being run by DCMS, GCHQ, and the Home Office. And this was published on the 10th of November. And it's VOCO, and it's the second report, which is the verification of children online. Excuse me. And this is how you can age verify children. There is standard 3 of the code, which is about age appropriate application. And VOCO actually goes further, because it's also about how you actually are obtaining content that is appropriate to children as well, but also you are verifying the age of the child. And then also launched last week, perhaps it's, you know, people have been delayed with things due to the global pandemic, that there's a flurry of activity, but I think it's both the global pandemic and just the nature of this area at the moment of children and data protection. But equally, there was a Digital Futures Commission that was launched on Friday last week, which was International Children's Day. And this is a 3-year project, which is a group of 15 commissioners that are working with the children's rights group 5 Rights. So plenty going on, and as Leonie mentioned at the outset, it is an international area. So as with the DPIA blacklists, whilst this is the first code of its kind, there is a lot of similar projects going on, and there has been, you know, some feeling that this is, you know, the benchmark, a bit like the GDPR was the global standard, and it is being implemented in countries, for example, in Brazil. We've seen Canada and New Zealand in recent weeks launch their own new data protection or draft legislation. So similarly, the thought is amongst certain speakers and influencers that the age appropriate design code is going to have a similar effect as the GDPR did. So I think that that's my conclusions for the moment. Leonie, back to you.
Great. Thank you very much, Lorna and Camille. And that brings us very nicely to approximately 15 minutes before the hour. So it leaves a little bit of time for questions if there are any. So feel free to put your questions into the question boxes. So while some other people are thinking about that, there is one. I think this is probably one for you, Camille. What appropriate measures should be in place where profiling does take place, such as where we are recommending content to children?
Right, okay, so the code sets out that the key is to ensure that children are not served content that is detrimental to them in terms of their health or their well-being. And they actually emphasize that if you are automatically recommending content based on profiling, you have a greater responsibility than if a child searched out the content themselves. In terms of the measures that they suggest one called contextual tagging. I'm not 100% familiar with what that one is, but others that they suggest include robust reporting procedures and also elements of human moderation. And they also suggest having making sure that you have editorial controls in place, and that if you're subject to any codes of conduct, that you make sure you're adhering to those. So I think those are their key suggestions there. And they also refer to making sure that if you consider content detrimental to children in one context, such as in terms of a film classification or marketing, for instance, then you should also assume that the same type of content is going to be harmful in other contexts as well. And they also set out that where you're not sure, you should exercise caution, should edge on the side of caution.
Great, that's very comprehensive. Thanks, Camille. So it doesn't look like there's any other. Oh, actually, I may have missed one. Let me just check. Yeah, there are a couple of questions. Yeah, if you wouldn't mind, actually, Camille, again, this is one for you. Just or in fact, actually, it's for you, I think, Lorna. Just a recap on the position on the default settings and having profiling switched off by default. That's possibly for Camille, actually, again.
Yeah, I'm just having a look at the question. Is your understanding of the code that any analytics, tracking, profiling, or similar have to be off by default for under 18s? Or is the concern tracking and profiling? Oh, I've just lost it. Tracking and profiling that is used to make some kind of decision rather than anonymous performance stats. So taking the first bit of the question, is our understanding of the code that any analytics, tracking, profiling, or similar have to be off by default for under 18s? No, so they only have to be off by default if you don't have a compelling reason for them to be on by default. And the ICO has set out a few compelling reasons, such as where they are sort of an intrinsic part of your core service. But in terms of analytics and sort of behavioral advertising, I think the ICO is envisaging that there are going to be very few situations where you can have, say, behavioral analytics or behavioral advertising even on by default, because they don't envisage any situations where having behavioral advertising would be a core part of a service, or very few examples. So I think I listed examples such as money off vouchers, and there's probably like few situations like that would apply to children. But in terms of, there are some other examples they give of situations where profiling can be on by default. So it can be on by default where it's necessary for compliance with regulation, including with the code itself, if you're carrying out any form of age assurance. And what were the other ones? Also safeguarding, for example. But they also set out that if you are carrying out profiling in order to provide news content feeds for children, then there might be circumstances when that could be allowed by default. Yeah, so I hope that helps somewhat with that one. Happy to look into that further and come back to you.
Thanks very much, Camille. And actually, there's another one which I think goes directly to the point we were making earlier about, services likely to be accessed by children. So there's a question about a social media page where it's not intended or designed to be accessed by children, but and it shouldn't be accessed by children in principle. But that actually children under 13 are viewing it and accessing it. Do you need to take account of this code? And I think based on the criteria that the answer is going to be yes to that. But if you wouldn't mind expanding on that as well.
Yeah, sure. So I mean, I think it's a tricky subject. It's a tricky
I think it's a
area.
reality versus regulation.
Yeah, absolutely. I mean, I think you need to sort of tread carefully with this one, because if you have sort of evidence, or if it would be very hard to plausibly kind of deny that there are children under 13 on your site, then I think the ICO would consider consider that you should be complying with the code. So I think it's about, if do you have a reasonable argument that children under 13 aren't using your site? I mean, it might be in certain situations, if you have particular measures that would make it very difficult for children under 13 to access your site, you could point to those. If you require sort of a credit card or certain measures like that, then you can point to that to say that it's unlikely that children under 13 are using your site. But if you know that children under 13 are viewing your site, and if it's going to be very hard to come up with ways to deny that, or arguments that you can arguments to kind of show that isn't the case, then I think you're going to have a hard time backing up that argument to the ICO. So I think, essentially, if you know that children under 18 are using your site, and under 13, even if that's not your sort of terms of use, unless you can point to measures that you have in place to make it very unlikely that many or a significant proportion are able to access the site, I think the ICO would expect you to comply.
Yeah, and if I could add to that, I suspect there's analogies to be drawn there with, other aspects of the GDPR, and in particular, if we look at some of the guidance from the EDPB, for example, on transparency, and it talks about, the level or the nature of your privacy notice needs to take account of your target audience. And you need to be checking as well on a regular basis that your target audience is your actual audience. So I would imagine that there's a similar expectation in the context of this code, that you couldn't ignore the fact that, as a matter of reality, there are children, and in particular, as Camille says, if there is a significant number of children accessing the site, the fact that you're not aiming the site at the children, or you're not intending it to be accessed by the children, is not necessarily going to get you where you need to be. Okay, I think there's a few other questions. Sorry, go ahead,
sorry,
Lorna.
Go ahead. No, I was pointing you out to those. I didn't know whether you'd enlarged your question box.
Yeah, I think there seems to be one more. Let me just pop this question mark out, actually, just to see. So there's a question about age gating, and I suspect in terms of some of the things that we're going to see in some of these workshops and some of these other initiatives that you've mentioned in the final slide, Lorna, we're going to see hopefully some further suggestions and some practical guidance around possibilities in terms of age gating. Would that be a fair
I think
assumption?
that although I think there's no specifics of age gating where there's going to be, you know, a lack necessarily of access, but more it's termed the age appropriate application and making the, you know, your services open to certain ages. But yes, as Camille was just saying, how do you do that to make sure you're verifying the age? And then I think, you know, the expressed sentiment in the code is that, you know, the ICO will be looking at what future technology is available in order to understand how age of users can be established with the correct, you know, accuracy. And I mean, there are various ways that examples that are given, but I think, you know, the technology will most certainly help. But I think the balance there is how much data you're actually collecting in order to verify the age. But I think there are some very clever technologies and developments, and I think, as we've also seen with the report from VOCO, there are very much ways in which to do that.
Yeah, and I think as well, it also comes down to that original criteria as well, doesn't it? You know, the probability that is it more probable than not that your service is likely to be accessed by children, and some of the age gating techniques will be relevant in that context. If you've got sufficient techniques in place that, you know, effectively make it very difficult for children, you know, under a certain age to access your site, then you'll be in the realm of making that type of argument that, you know, it's less probable that they will be able to access your site, and so that, you know, the age gating will come, you know, will be relevant in that context also. And I think we've covered most of the questions. To the extent that there are any others, we'd be very happy to follow up. A recording of this session will be made available and sent out to anyone who's registered subsequently. Yes, Chloe will make sure that that's the case in relation to anyone who wants to receive a copy of the recording. So thank you very much for your attention today. I hope it's been useful, and we'll see you hopefully at our next webinar. Thank you. Bye.
Thanks. Bye.